Good afternoon and welcome to Facebook Live. My name is Emma Peterson.
And my name's Nicholas Briggs.
And today we're going to be talking about how and when to appeal your VA decision. A lot of the information we're talking about today is going to be available in more detail on our website at www.cck-law.com. And of course, as always, if you have questions for Nick and I as we talk about how to appeal your case today, please feel free to leave it in the comment section and we'll do our very best to get back to you. So, diving right in, Nick,
Yep.
Why appeal a claim?
Well, the reason you'd want to appeal a claim, generally speaking, is either it denied your claim or it didn't give you the highest rating that you were looking for. And if you don't appeal that decision, it becomes final. So whatever VA decided is the end of the matter.
Right. And so we're going to be talking about initial claims today, so initial rating decisions that you're just getting for the first time from VA. So if you already have an appeal in the system, particularly if you're in the old system and not the new Appeals Modernization System, which we have a lot of information about on our website. Not everything in this conversation will apply to you. But going forward, if you're interested in how to appeal your initial claim, we're going to do our best to cover just the broad strokes on how you can do that and why you'd want to. So as Nick said, you'd want to appeal because you were denied whatever you're looking for. And typically you have a year from the date of that decision to do so. So you're going to get a decision and you're also going to get a cover letter that's called a notice of action letter. It has a date at the top. You have 1 year from the date of that decision to file your decision. But I'm sure there are folks out there wondering what happens if I missed a deadline.
Sure. So at that point, you're going to need to file a new claim. Like Emma mentioned, you do have that 1 year to file an appeal. But one of the benefits to filing the appeal within that 1 year is, one, making sure that you don't need to file a new claim, and two, preserving your effective date from your original claim.
And the effective date is important because that's the date VA is going to pay you from. So if it's a grant of service connection, it's going to be from that effective date forward. If it's an increased rating, same thing, but it boils down to how much is your retroactive award going to be, how much money are you going to receive, and from what date is that going to proceed from.
Exactly. Hey, Emma, what's the best time to appeal the decision?
So the best time, obviously, is before the deadline, but you certainly want to, look and see what you need to win your case. So if you need to make a link between your current diagnosis and your in-service period, maybe you want to wait until you have something in writing from your doctor describing that nexus between the two things. Or if you're trying to prove the severity of condition, same thing. Wait till you have some medical evidence, or you have a buddy who can write a statement for you describing how severe your symptoms are. Wait till you have that evidence and then submit it to VA. So make it really easy for them to connect the dots and just grant you the benefit out of the gate.
Sure. And at the end of the day, there are going to be times where you don't necessarily have that evidence right away. And at least while you're working at the regional office level, you can certainly file the appeal. And depending on which lane you choose in the new Appeals Modernization System, you can submit additional evidence after the appeal's filed.
Right.
But you want to make sure that you're being careful about which lane that you're choosing, because that's going to determine what you can actually submit and when.
Right. So as Nick said, in the new system, if you want to appeal a decision, and again, all this information is on our website, in our blog, and in other Facebook Lives. But in the new system, you can pick a new lane after you get a decision. But in the old system, in the legacy system, you'd have to file a disagreement and a couple other appeals in order to get that decision reconsidered. But if you're getting a rating decision today, or you received a rating decision since February 19th, 2019, you're most likely in the new system unless something has gone wrong at the RO level.
Exactly. Can you have an appeal in both systems at the same time?
So you can, but it has to be for different issues. So you can't have, an increased rating for your left knee in the legacy and in the new AMA system. You have to pick one. But you can have increased rating for your knee in the AMA system, and maybe you have an old service connection for PTSD claim pending in the legacy system, and you don't want to move it. So you can personally have multiple claims in different places. It just cannot be for the same issue.
Sure.
Yeah. So we talked about lanes. So what are your options for appealing a new rating decision that you get, today? It's in the AMA system.
Sure. So there are 3 different lanes that you can choose from. You can either choose the higher level review lane, the supplemental claim lane, or the board lane. We'll start with the higher level review lane first, and then we'll work our way through to the others. Okay. But what happens when you choose to have your claim reviewed in the higher level review lane?
So higher level review, it's going to go to a more senior person at the regional office, sort of a super rater, someone that wasn't involved in the initial decision-making process, and they're going to review all the evidence in your claim file de novo. And that means they're going to look at it anew from the beginning, with fresh eyes. They're not bound by anything that initial rating decision found other than favorable findings of fact. They do have to continue those throughout your appeal period. They can't, if someone found you have a diagnosis of PTSD, someone can't then say you don't have it. But they're going to look at it everything fresh. And so that really is the best option if you think just a procedural mistake's been made, maybe a typo's been made, something like that, where the evidence is very clear, you have everything you need to win, and for whatever reason, it just was overlooked, or, VA made a typo error in terms of assigning a date or a rating. But that's where you want to maybe pick the higher level review lane.
Sure. And one of the things to keep in mind here is that it's really a focus on all of the evidence that's already of record, because once you're in the higher level review lane, you can't submit new evidence.
Right. That's very important. So you mentioned that there's 3 lanes. We've got higher level review. What happens in the supplemental claim lane?
In the supplemental claim lane, you're providing the VA with new evidence, new and relevant evidence that supports your claim for service connection, your claim for an increased rating, whatever the issue might be. So this is really your one chance to provide the VA with new evidence. But here you're going to want to make sure that you're submitting it as soon as possible, or you're at least identifying the information that VA can go out and get, like records for treatment at VA facilities, any private records, things like that.
So if I submit the form, because now there's a form for each lane, make sure you look at that carefully. If I submit a form for a supplemental claim and it's within the year from my initial rating decision, but then I don't get my supplemental evidence to VA until outside of a year, am I going to have met the appeal period?
As long as you identified it, the fact that they didn't receive it before the expiration of the year is fine. It's identifying the new and relevant evidence. VA has the duty to assist at that point to go and get the evidence. But
if I just submit the form and don't say anything, that's not going to be considered a supplemental claim, right? It's kind of tricky that way.
Yeah, so in that case, you'd really want to make sure that you're getting it as soon as possible, because if you go outside of that year, it could go either way as to what VA will do. So
this is really the best lane to pick if, like as Nick said, you have additional evidence to add. You can take a look at your initial rating decision, figure out what's missing. VA should tell you, what is the missing link. You don't have a diagnosis. You don't have a next opinion from a doctor. We can't find any service records that confirm this. It gives you an opportunity to go out and find that information. And rather having to go through a lengthy appeal process up to the board, you can hopefully just fix it at the ground level at the regional office.
And again, this is the one area of the new system where the duty to assist applies. So if you do provide this evidence, either showing that you were injured in service or showing that you have a current diagnosis, that's the time when the VA is going to go out and get a VA medical opinion on their own if there's any question as to whether or not service connection for your condition is warranted.
Okay.
And then the last lane that we wanted to talk about is taking the case to the Board of Veterans Appeals. So how is a notice of disagreement in the new system different from a notice of disagreement in the old system?
Sure. So in the old system, you'd file the notice of disagreement, identifying what you disagree with. You'd wait a year, 2, 10 for VA to issue a statement of the case, which really would just 9 times out of 10 reiterate in sort of short form the reasons why you were denied by the regional office level. You then have to file within 60 days a VA Form 9 saying, no, I really mean it. I'd like to appeal. And if you miss that deadline, your appeal will be over. But let's say you file it. And then you'd have to wait a series of months to years for the VA to certify your case to the board. And then eventually, again, 5-6 years later, you might end up with a board decision from a board member at the Board of Veterans Appeals. So that was the old appeal system. Now, with a notice of disagreement to the board, you skip those middle steps. You skip the statement of the case, you skip the VA-9. It's just an appeal directly to the board saying, no, I really mean this. I want someone at the board to look at my case. And you can pick from 3 different dockets at the board.
Yep, exactly. So the 3 different dockets that you can choose from are direct review, which is review of the evidence that was of record at the time of the previous decision issued by the regional office. You could also choose the evidence docket, and that allows you 90 days in which to submit additional evidence following your election of the evidence lane choice. And then finally, there's the hearing docket, which would entitle you to attend a hearing before either in Washington, D.C. or by video conference, in which a hearing officer will go through your case for you, and you can answer any questions related to your appeal.
Now, there are certainly pros and cons to picking each docket, one of which has to do with the time in which they're going to be addressed, and we have information about that up on our website. But the direct review docket is sort of like the higher level review lane at the RO, except it's at the board. So if you have a case where there's sort of a question that's legally complex, maybe it's something more unusual that raters don't see every day, you might want to pick that docket. But that's if you have all the evidence you need in the file already. For the evidence docket, it's kind of like supplemental claim lane. You get to add some evidence into the record, whatever's missing. But again, same thing. You want to get out of the regional office. You want to go to the board. You want to have a board judge address your case, have one of the lawyers at VA review the case and issue a decision. And then finally, the hearing docket. There are certainly cases in which a hearing can be very beneficial. And if you want to speak to a board member, you absolutely have a right to do that. And you can submit some evidence at the hearing docket. So it gets a little tricky, but at the time of your hearing, when you physically have the hearing, you can submit new evidence. And then I think you have 90 days after your hearing to submit evidence, and then the window closes again. So it's a little confusing, but...
And again, at the end of the day, you don't necessarily know when the hearing is going to be scheduled.
Right.
We're talking on the order of years before it could be the case that your hearing scheduled. So at that point, it might be hard to know what evidence you need to submit to identify evidence based off of the period on appeal. So depending on the situation, save yourself some time and don't choose the hearing unless there's a very good reason to do it.
Right. And I think one good point to know overall is that, as we talked about, the supplemental claim lane is the lane in which VA has a duty to assist. The board doesn't have the duty to assist anymore. They used to in the legacy system, but you can't rely on the board to look and say, oh, you know what, this has been a passage of time, the condition is worse, let's get a new exam. They're not going to do that anymore. The only time in which the board would say something needs to go back to the regional office for a duty to assist error is if it's already happened. So that initial exam VA got for you, you identified service records and VA never went out and got them, something like that, something that's already happened in the past, but something that's happened since then along the way to the board is not going to be something the board's going to help you with, unfortunately.
Yeah, exactly. So all they can do in that situation is at least identify the duty to assist error that occurred in the supplemental claim lane. But from there, it effectively requires a remand back to the supplemental claim lane for the regional office to correct that duty to assist error, to get that adequate VA examination, whatever the case may be, which makes you start the process over again. So ultimately, you're able to maintain your effective date when that happens, but you want to make sure that you're staying on top of it, especially as your appeal works its way through.
What happens if I choose the wrong lane? I pick higher level review, but then I realize, you know what? I've reconnected with my friend from service. He can verify everything I'm saying happened in service, and I want him to write me a letter. What can I do then?
You have within the initial year of the initial rating decision to change your selection. So if you initially opt into the higher level review lane, as long as that decision doesn't come in, you can change your choice. But at the end of the day, there's no harm in receiving a denial in the higher level review lane and then filing a new supplemental claim within a year of that decision, submitting the new evidence that you mentioned.
Now, some lanes are going to be faster than others, and some of it's pretty intuitive. So, for example, direct review of issues, whether at the regional office or at the board, will probably be faster than situations in which evidence needs to be reviewed. But certainly it's an important issue to discuss with either your attorney, your accredited agent, your VSO, with our colleagues at DAV, to help you figure out what lane to pick, what's going to be the fastest and best lane for you, because there's sort of two things to consider. How fast is VA going to decide my appeal, and what do they need to decide my appeal? So it's going to take a little bit longer, but it's going to result in a favorable, decision. You might want to pick that lane. But again, it's tricky, it's untested, it's new. So definitely reach out to someone to figure out which one of these lanes to pick.
Absolutely.
Now, what if the decision you appeal to the board is unfavorable? What next?
So at that point, you have two options. You could file a new supplemental claim in which you provide new and relevant evidence, or if it's a legal error, that is the board is clearly either ignoring the law or not applying it correctly, you still have the option to appeal the case back to the Court of Appeals for Veterans Claims. Okay,
so the CAVC, just briefly, is a federal court in D.C. They're outside of the VA system. They hear exclusively veterans' disability cases from VA and a couple other things, but again, only VA cases, but it's not part of VA. They are, real federal judges, and this is all they consider day in and day out, 365 days a year. But one of the interesting features, and again, untested points so far that I know of, is that under the new system, you can actually file a supplemental claim off of an unfavorable court decision. It used to be that was either the end, or you'd have to appeal to the federal circuit and then maybe the Supreme Court, and that's all very difficult to do. Now, if the court, issues a decision and says, nope, the board did everything right, and here's why, you have an opportunity to file a supplemental claim within a year of the court decision, maybe fixing that mistake, adding more evidence to counteract whatever it is the court found.
Yeah. And it's also important to keep in mind that the appeal timeframes for taking the case to court are a bit different. Under the new system, the rule is pretty exclusively 1 year after the date of the decision. But in the case of a negative board denial, you only have 100 days to file, or 120 days to file the appeal to court.
Right.
So keep that in mind. Ultimately, if you are unfortunately make it past that 120 days and you can't show good cause for why you missed the appeal deadline, it's not the end of your case. You do still have the opportunity to file the supplemental claim.
Absolutely. Nick, do you have any tips or things to remember for veterans who are about to submit an appeal?
Just know your deadline. Make sure that you're within that 1 year. Know which lane you're going into and why. And if you don't know which lane to go to, seek representation. Go to your representative if you have one.
Right.
Because they're going to be able to walk you through the system as it develops.
Okay, so we have a question from Sherwin about forms, my favorite. All right, so if you choose the appeal to the board lane, then a VA form 10182 must be used and sent to the BVA in DC. I don't know the numbers off the top of my head yet. I will, but possibly.
Sure. So at the end of the day, they do have a new NOD form. We're not sure of the exact number. That appears to be.
We're getting a thumbs up that it's the number.
But unlike the legacy system where you would file the notice of disagreement with the regional office, in the new system, yes, you need to directly file that notice of disagreement with the board, because the regional office usually isn't going to forward it to the board for you.
Right. So NODs no longer go to the RO. They go to the Board of Veterans' Appeals in Washington, D.C. And hopefully those instructions are somewhat clear on the form itself. If there are any other questions, we're happy to answer them. Other than that, thanks for joining us with today's brief but hopefully informative CCK Live on how and when to appeal your decision. I'm Emma Peterson.
I'm Nicholas Briggs.
And thanks for joining us.